A stand your ground law states that a person may use force in self-defense when there is reasonable belief of a threat without an obligation to retreat first.
Stand your ground laws are designed to protect law-abiding citizens from unnecessary physical harm or even the risk of death. However, the language of the law and purposeful vagueness has allowed for more danger and has put the citizens of our community at harm. Our society has been increasingly aware of our rights and is now has the capability of using these laws in extreme manners, such as using the use of deadly force when it's not needed.
Before the enactment of Stand Your Ground, a person who was about to be assaulted had to retreat as far as possible before protecting himself. The Stand Your Ground law is the only protection that law-abiding citizens have to protect themselves and family from the common criminal without fear of being prosecuted. Bad people are armed and stand their ground, and good people must be able to do the same.
Stand your ground laws should be altered using better legal language and made less vague. The law reads as follows: a law which places no obligation on a potential victim of a crime to retreat and call police. The victim is instead allowed to respond to force with force, even if flight is a possibility. This is a jargon database. The letter of the law varies from state to state, and in each state, one must decide and use basic reasoning when they're deeming what's a reasonable threat of harm or risk or danger. But who's to say what's reasonable? What a 40-year-old man may deem reasonable is completely different than the reasoning of a 20-year-old boy.
I think if you honestly believe that a person is about to use unlawful, deadly physical force against you, you should have the right to defend yourself. If you think he's about to kill me, you are reasonable in that belief. You shouldn't have to wait until the gun comes out of the pocket and is aimed at you. I would wager that those who are against the stand your ground laws are almost universally against the right to even own a gun. When is the last time you saw an anti-gun advocate post a sign in their yard or on their door that proclaims to the bad guys that their home is unarmed? The Trayvon case aside, do you honestly believe people shouldn't be able to own guns for protection?
I think people have every reasoning and every right to own a gun. However, I feel like there needs to be stricter laws in deeming who can have a gun. Clearly, a person with a felony on their record should not be able to carry a deadly weapon. But then I find a case like this where there's George Zimmerman, who has a history of violence and a criminal record, but he's allowed to carry a weapon. Also, I think a person's mental stability should be put into play when issuing guns. Would you really want a crazy person running around with a gun just because they can legally have one? I don't think that advocates public safety at all.
So what you're saying is that a person with mental issues doesn't satisfy certain attributes of a citizen, thus shouldn't be allowed to protect themselves. Correct me if I'm wrong. Next, you'd be saying that those with physical issues shouldn't be trusted. You're saying that those with arthritis, wheelchair dependencies, and etc. shouldn't be trusted with guns based solely on the fact that they're physically handicapped. This isn't 16 and 1700 England. Most violence comes from firearms. We shouldn't put citizens in a position of having to wonder if they're threatened with a gun should they run. There should be no wondering. If you face a threat, you have no obligation to retreat. The safety of citizens is really all that matters.
I mean, by no means am I saying a citizen is not a citizen and doesn't have rights based on their mental or physical disabilities. But I do believe a person with a mental disorder may not understand the serious responsibility of owning a firearm and then in turn can harm themselves or harm another person. All in all, I feel like public safety is the main goal, and allowing certain people to carry firearms and having protection laws, such as stand your ground, are doing more harm than good because they allow room for justifiable murder. Honestly, it seems as though we're promoting a culture where people can take the law into their own hands, and I never knew that vigilantism was accepted. And also, with looking at statistics, before Stand Your Ground came into play, Florida averaged 12 cases of justifiable homicide per year. Since the law has been passed, it's now 3 times higher at about 36. Georgia averaged 7 per year before stand your ground. Now they're at 14. Texas averaged justifiable homicides at about 26 before the passing of the law, and now they're at a booming 45. Clearly, public safety isn't being kept if more lives are being lost.
Well, with your research, did you also notice that the violent crime rate of the U.S. decreased 13.2% from 2006 to 2010? In addition to the U.S. murder rates decreased to 14.8% during the time frame. I disagree with your statement that we're promoting a culture where people take law into their own hands and face no consequences for it. There are consequences for the aggressor. It's not okay to threaten someone, regardless of any circumstance. When faced with a threat, most first reactions aren't to retreat. It's to preserve your life. There is no viable option but to take the law into your hands to protect yourself. If that's the case, what's the point of self-defense, martial arts, or anything else of that nature? Cops can't be everywhere civilians can be. So at the end of the day, protecting oneself is important. I guess the main point I'm getting at is that how do these laws get approved if it's so self-evident that they're counterproductive?
I'm saying, yes, violent crime and murder are decreasing as a whole. But if you look specifically at the types of murder, justifiable murder is increasing. I think these people are no doubt getting away with murder just because they can simply say, I feel threatened, and then they can take any action they see fit because you can't tell them that they didn't feel threatened. Even people that are the aggressor know this and use it to their full advantage when claiming self-defense because they know these poorly written stand your ground laws are here to protect them. If lawmakers are really advocating public safety, this wouldn't be allowed. The law as written now discusses force with equal force. So it's kind of funny that fistfights often turn into a situation where a person is shot dead. And I don't understand that. I firmly believe these laws need to be repealed or altered to advocate public safety. And the right to self-defense needs to be given under strict circumstances because saying simply, I felt threatened is not enough. The self-defense doctrine is one of necessity, and it should be a last resort.
That's like saying we can't get convictions on any murders. How can we determine if they were justified? We might as well give up on murders in general. Not every state has stand your ground laws, and not all are the same. So to make that hasty generalization isn't the best argument. You yourself mentioned that the law discusses force with equal force, but you mentioned a fist fight and a gun battle. Clearly the two aren't equal, but throw in some circumstances of threat, a significant weight or age difference, and you have the right to protect yourself. The statute in Washington state appears to be pretty straightforward. SB 5418 seeks to expand that law in cases where the slayer has a reasonable fear of imminent peril or death or great bodily harm. The law allows use of deadly force in the lawful defense of oneself, a family member, or any other person, when there is reasonable ground to prevent actions of the person slain to commit a felony or to do injury or harm, and there is imminent danger of such design being accomplished, or in the actual resistance of an attempt to commit a felony upon the slayer, on those in their presence, or in a dwelling, or other place of abode in which they are. What level of clarity must be reached? The argument is if the law in its entirety is beneficial to citizens, and I once again think that it is.
I gotta give the state of Washington credit because their law seems to be one that's pretty well written. But I'm trying to figure out why every state can't follow this suit and make similar changes to stand your ground doctrines. Like going back to George Zimmerman in the Trayvon Martin case, looking at the Florida laws, there clearly is a flaw. Florida's use of force in defense of a person. A person is justified in using force, except deadly force, against another person when and to the extent that that person reasonably believes that the conduct is necessary to defend himself, herself, or another against another's imminent use of unlawful force. However, a person is justified in the use of deadly force and does not have the duty to retreat if he or she reasonably believes that the force is necessary to prevent imminent death or great bodily harm to himself or another or herself, or to prevent the imminent commission of a forcible felony. The law says one thing, and then with a little rewording contradicts everything it previously said. I'm actually trying to figure out how George Zimmerman was protected under this very law. Where was the deadly force that Martin used that allowed for Zimmerman to use a similar level of deadly force? If going with the Florida law, Zimmerman had no right to act in the way he did. Comparing the two states of Washington and Florida, there are clear discrepancies in the laws that can allow for confusion. I just think these laws need to be amended to fit the circumstances where self-defense actually occurs.
Does the application, my key word here, application, of the law by the government in that particular case invalidate it in its entirety or make it less credible? The argument here, unfortunately, isn't whether Zimmerman was correct in his claim. The argument is, however, if this law is beneficial. It is beneficial to citizens because as a citizen, you have a right to protect yourself at any cost. Elimination of this law eliminates the feeling of protection accompanied with having a firearm or whatever is considered as protection. Force doesn't necessarily mean a gun, nor does it always result in killings. You have to not only think about Trayvon Martin in your determination. Consider women who injure their attackers opposed to retreating, which may actually be worse. Are they wrong? They're doing what they need to do to protect themselves. They are, in all reality, standing their ground.
The application of the law in its context now is where the problem lies. Moving away from Trayvon Martin and the Zimmerman case for a moment and focusing on women, which you brought up, that injure their attacker. These laws are allowing the wrong kind of force to be used, as I see it. Yes, women and anybody have every right to defend themselves and stand their ground, but the way that these laws are being used, it's allowing for women who say were slapped by their husband to fight back and stab them in turn. The force is nowhere near equal. And I feel like these laws need to be more strict and to define the terms better and include several amendments like allowing drugs, robbery, and other illegal acts that are associated with the victim and or the aggressor to not be used under the terms of these laws. Also, demographics like race and gender, sexual orientation, and religion shouldn't be used under the conditions of the law as well. I feel like with certain changes, the stand your ground laws can be effective in advocating public safety and protecting the rights of these citizens.